Hello. I am the Sleepy Solicitor, and tonight, I invite you to join me as we leaf through the dusty archives of the past. This is the story of Pierson versus Post, known simply as the Fox case, a tale that begins with a chase across the dunes and ends with a question that has occupied legal minds for over 2 centuries. When does something wild become yours? Take a deep breath. Let's begin. It's a crisp autumn morning in 1802, and the salt air carries the scent of the Atlantic across the barrier beaches of Southampton, Long Island. The island in these days is nothing like the summer resort it will become. It's rural, agricultural, a place where farmers and fishermen make their living from the land and sea. The Southampton of 1802 is a community where everyone knows everyone, where family names matter, and where disputes, even small ones, can simmer for generations. Lodowick Post wakes before dawn. He's a member of the Post family, one of the established names in the area. The Posts are respectable people, landowners, the kind of family that's been on Long Island since the colonial days. Lodowick is a young man, perhaps in his 20s or early 30s. The historical record doesn't give us his exact age, but we can imagine him as vigorous, energetic, someone who takes his recreational pursuits seriously. Fox hunting is one of those pursuits. In early 19th century America, fox hunting is both sport and necessity. Foxes are considered vermin, pests that raid chicken coops and threaten farm animals. They're cunning creatures, difficult to catch, and there's a certain prestige in being a skilled fox hunter. It's not quite the elaborate British tradition with its formal dress and rigid protocol, but it's still a social activity, something that marks you as a gentleman of leisure, someone with time and resources to pursue game. On this particular morning, Lodowick Post has his dogs with him. The historical record tells us he has hounds, likely a small pack, trained for hunting. These aren't pets, they're working dogs, bred and trained specifically for tracking and pursuing foxes. We can imagine their excitement as they sense the hunt beginning, their tails wagging, their noses already searching the air for scent. The beach where our story unfolds is wild, undeveloped land. It's not clear whether this beach is owned by anyone in particular, or whether it's considered common land, open to all. This ambiguity will become important later. For now, picture a long stretch of sand, sea grass bending in the wind, the sound of waves providing a constant backdrop. It's the kind of place where you can see for miles, where there's nowhere for a fox to hide except among the dunes and scattered vegetation. Lodowick Post's dogs pick up a scent. Their behavior changes, more focused, more urgent. They found a fox trail, and the chase is on. Before we continue with our chase, let's pause for a moment to consider the fox itself. In the law, this will become important. What kind of creature are we dealing with? The fox is what lawyers called Ferae Naturae, wild by nature. This is a Latin term, one of many that pepper legal discourse, a remnant of the Roman law that forms the foundation of much Western legal thinking. Ferae Naturae animals are those that live in a wild state, that belong to no one, that are by their nature free. This is different from Domiti Naturae, animals that are by nature tame, like cattle or sheep or chickens. Domestic animals are presumed to belong to someone. They have owners. But wild animals? Wild animals belong to no one until someone claims them, captures them, takes possession of them in some recognized way. The fox knows nothing of these legal categories, of course. The fox is simply trying to survive. It's a red fox, most likely, Vulpes vulpes, the common red fox that ranges across North America. An adult fox weighs perhaps 10 to 15 pounds, with russet fur, white underbelly, and that distinctive bushy tail. Foxes are solitary creatures, clever and adaptable. They're crepuscular, most active at dawn and dusk, though they'll hunt whenever opportunity presents itself. This particular fox has made the mistake of leaving a scent trail that Lodowick post's well-trained hounds can follow. And now, the fox is running for its life. The chase is on, and Lodowick post is fully engaged in the hunt. His dogs are baying, following the scent trail across the beach. Post follows on horseback. The historical record suggests he's mounted, as was typical for fox hunting. The image is vivid: man on horse, dogs running ahead, all moving across the open beach in pursuit of a fleeing fox. This is not a brief chase. Fox hunts can last for hours. The fox is fast and clever, capable of doubling back, running through water to break its scent trail, hiding in burrows or dense vegetation. But Lodowick post's dogs are trained for this. They're persistent, working as a pack, and Post himself is experienced. He knows how to read his dog's behavior, how to anticipate where the fox might go. In the language of the law that will later examine this case, Lodowick post is engaged in hot pursuit. This term has a specific meaning in legal contexts. It's not just chasing, it's an active, continuous, determined pursuit with the intent to capture. Post isn't merely following the fox casually. He's committed to the hunt, invested in the chase. His dogs have the fox in view, or at least very close to it. The pursuit is earnest and uninterrupted. We might imagine Post's thoughts during this chase. Perhaps he's calculating where the fox might go, what terrain lies ahead. Perhaps he's feeling the thrill of the hunt, that ancient human pleasure in the chase. Perhaps he's already thinking about what he'll do with the fox once caught. The pelt has some value, and there's the satisfaction of having rid the area of a pest. The fox is tiring. The dogs are closing in. The moment of capture seems imminent. And then, something unexpected happens. Jesse Pierson appears on the scene. Like Post, Pierson is a local man, another Long Island resident. The Pierson name is also well established in the area. In the small world of early 19th century Southampton, the Posts and Pierson certainly know of each other, move in the same general social circles. What exactly happens next is subject to some interpretation, because the historical record gives us only the bare facts. What we know is this: Jesse Pierson, seeing the fox that Lodowick Post's dogs have been chasing, this exhausted, fleeing fox, kills it and carries it away. Imagine the scene. The fox, perhaps cornered or simply too exhausted to run further, is killed by Pierson. Maybe he shoots it. Maybe he clubs it. The court record doesn't specify the method, only the result. Pierson takes possession of the dead fox. Now imagine Lodowick Post's reaction. He's been chasing this fox, possibly for hours. His dogs have done the work of tracking and pursuing. The capture was moments away. And then, this other man, this interloper, as Post surely sees him, simply steps in and takes the prize. Post is, we can assume, furious. There's a confrontation on the beach. We don't know the exact words exchanged, but we can imagine them. Post claims the fox is his. His dogs chased it. He was in hot pursuit. The fox would have been his in moments. Pierson, presumably, has a different view. The fox was wild, belonged to no one, and he killed it. Possession, perhaps he argues, is 9/10 of the law. They cannot resolve their dispute on the beach that day. And so, as neighbors and gentlemen of property do in the early American Republic, they take their disagreement to court. Before we enter the courtroom, let's step back and consider what this case is really about. On the surface, it's about a fox, a small animal of limited monetary value. But underneath, it's about something much more fundamental: the nature of property itself. What does it mean to own something? This question seems simple, but it's occupied philosophers and jurists for thousands of years. Property is one of the foundational concepts of organized society. The rules about who owns what, how ownership is acquired, how it's transferred, these rules create stability, enable commerce, prevent constant conflict. For most objects, ownership is clear. If you make something with your own hands, it's yours. If you buy something from someone who owns it, it becomes yours. If someone gives you something as a gift, it's yours. These are straightforward transactions. But what about things that have never been owned? What about the wild creatures of the earth, the fish in the sea, the birds in the air? These things exist in nature, belonging to no one. How does ownership begin? This is the question that Pierson versus Post forces the court to confront. It's a question that goes back to ancient Rome, to medieval England, to the fundamental principles of property law. And it's a question with practical implications far beyond a single fox on a Long Island beach. Roman law had various theories about acquiring property in wild animals. One principle was that wild animals became property through occupancy, taking physical possession. But what counted as possession? Did you have to actually hold the animal in your hands? What if you wounded it and were tracking it? What if your dogs had it cornered? Different Roman legal scholars had different views. Justinian's Institutes, the great codification of Roman law from the 6th century, said that a wounded wild animal remained wild until actually captured. If it escaped, it returned to its natural liberty, and anyone could take it. But other authorities suggested that wounding an animal with the intent and ability to capture it might create some claim. Medieval English law, which formed the basis for American common law, had its own traditions around hunting and property. In England, hunting rights were often tied to land ownership and social class. The nobility had the right to hunt in certain areas. Poaching, taking game from another's land, was a serious offense. But these rules were about respecting property rights in land and social hierarchy, not necessarily about the moment when a wild animal became property. By the time Lodowick Post and Jesse Pierson bring their dispute to court, American law is trying to work out its own principles, drawing on these ancient sources but adapting them to a new context, a democratic republic without nobility, a vast continent with abundant game, a society that values both individual liberty and property rights. The question before the court is deceptively simple. Did Lodowick Post acquire property rights in the fox through his pursuit, or did Jesse Pierson acquire those rights by killing and taking possession of it? The answer will require the court to choose between different theories of property, different understandings of what it means to own something that was once wild. Lodowick Post sues Jesse Pierson for trespass on the case. This is the form of action, the legal procedure, used for this type of dispute. Post is claiming that Pierson wrongfully interfered with his property right in the fox. The case first goes to a local court. We don't have extensive records of this initial proceeding, but we know the outcome. Post wins. The local court agrees with him that his pursuit gave him a superior claim to the fox. Pierson is ordered to pay damages. But Jesse Pierson is not satisfied with this outcome. He appeals to a higher court, the Supreme Court of New York. This is the highest court in the state, though at this time it's also a trial court for certain cases. The court sits with a panel of judges who will consider the legal arguments on both sides. The case is argued in 1805, 3 years after the incident on the beach. By now, what started as a dispute between two neighbors over a fox has become a matter of legal principle. Lawyers have been hired. Briefs have been written. Ancient legal authorities have been consulted. The judges hearing the case are men of learning and standing. This is still early in American legal history, a time when the common law tradition is being adapted to American circumstances, when courts are establishing precedents that will guide the law for generations. Let's imagine the courtroom. It's likely a simple space by modern standards, wooden benches, perhaps a raised platform for the judges, plain walls. The judges wear robes, maintaining the dignity and formality of the English legal tradition. Lawyers for both sides present their arguments. Lodowick Post's lawyer stands to argue his client's position. The argument goes something like this. My client was engaged in hot pursuit of this fox. He was hunting it with dogs specifically trained for this purpose. The pursuit was active, continuous, and determined. The fox was being chased across open beach where there was every likelihood of capture. But for Mr. Pierson's interference, Mr. Post would certainly have captured the fox within moments. To allow Mr. Pierson to take the fox under these circumstances would be unconscionable. It would reward interference and discourage the beneficial activity of hunting vermin. It would mean that anyone could lurk about, waiting for others to do the work of pursuit, and then simply step in at the last moment to steal the prize. The lawyer likely cites legal authorities to support this position. He might reference Pufendorf, a German philosopher and jurist whose work on natural law was influential. Pufendorf suggested that pursuit alone could create an inchoate property right, an incomplete but real claim that should be protected against interference. He might cite Barbeyrac, a French legal scholar who commented on Pufendorf's work and argued that an animal should be considered as belonging to the pursuer once it's so exhausted by the chase that capture is inevitable. The argument for Post is based on several policy considerations. We should encourage the hunting of harmful vermin like foxes. We should protect those who do the work of pursuit from those who would simply interfere and steal the fruits of their labor. We should recognize that actual physical possession isn't the only way to acquire property. Sometimes a near certainty of capture should be enough. The lawyer for Post paints a picture of his client as a diligent hunter, performing a useful service to the community, who has been wronged by an opportunistic interloper. Now Jesse Pierson's lawyer rises to present the opposing argument. His position is different, but no less grounded in legal principle. The fox was a wild animal, he argues. Wild animals belong to no one until they are actually captured and reduced to possession. This is the clear rule from ancient times to the present. Mere pursuit, no matter how close or how determined, does not create ownership. Mr. Post did not have the fox in his possession. His dogs had not caught it. He had not trapped it. The fox remained free, capable of escape. Under these circumstances, the fox remained wild, Ferae Naturae, and anyone was free to take it. Mr. Pierson killed the fox and took possession of it. At that moment, by the well-established rules of property law, it became his. He did not steal from Mr. Post, because Mr. Post owned nothing. You cannot steal what belongs to no one. Pierson's lawyer also cites ancient authorities. He references Justinian's Institutes, which clearly state that a wild animal must be actually captured to become property. He might cite Bracton, a medieval English legal writer, who said the same thing. And Pierson's lawyer raises practical concerns. Where would we draw the line if mere pursuit created property rights? Would it be enough to see a fox in the distance and start walking toward it? Would merely having the intent to hunt be sufficient? Without a clear rule that requires actual possession, we would have endless disputes about who was close enough to capturing a wild animal. The rule that requires actual possession is clear, definite, and easy to apply. Everyone knows when an animal has been captured. But claims based on near capture or inevitable capture are vague and subjective. They would create more disputes than they resolve. The lawyer for Pierson paints a picture of his client as someone who simply exercised his lawful right to take possession of a wild animal that belonged to no one. The judges retire to consider the arguments. They deliberate on this question that has been debated since Roman times: what creates property in a wild animal? When they return with their decision, it's divided. This is not a unanimous court. 3 judges form the majority, and they rule in favor of Jesse Pierson. But one judge dissents, arguing passionately that Post should have won. The majority opinion is written by Justice Tompkins. His reasoning follows the argument that Pierson's lawyer made. He begins with the fundamental principle: wild animals are owned by no one until they are captured and reduced to possession. Justice Tompkins acknowledges that mere pursuit is not enough. To rule otherwise, he writes, would create too much uncertainty. How close must the pursuit be? How inevitable must the capture be? These are questions without clear answers, and the law prefers certainty. He cites the Roman law authorities, particularly those that require actual possession. He notes that Justinian's institutes clearly state that even a mortally wounded animal that escapes returns to its natural state of freedom and may be taken by anyone. The opinion recognizes one exception to this rule: if the pursuit takes place on the hunter's own private land, then interfering with that pursuit could be a trespass against the landowner. But this case took place on a beach, land that was apparently not privately owned by Post. On such land, anyone has the right to hunt. Justice Tompkins acknowledges that his ruling might seem harsh, that it rewards Pierson for what seems like unsportsmanlike conduct. But the law, he suggests, must be based on clear principles, not on subjective judgment about who was more deserving. The majority's conclusion is straightforward. Pierson killed and took possession of the fox. At that moment, it became his property. Post's prior pursuit gave him no legal claim. The decision is carefully reasoned, drawing on centuries of legal authority. But it's not the only possible decision, as the dissent will make clear. Justice Livingston writes a dissenting opinion, and it's every bit as learned and well-reasoned as the majority opinion. This is the beauty of appellate law: the same facts and legal authorities can lead thoughtful judges to different conclusions. Justice Livingston begins by acknowledging that absolute certainty is desirable in the law. But he argues that the majority's rule doesn't actually provide certainty, it will lead to different disputes. If anyone can take a wild animal until the moment it's physically possessed, hunters will be reluctant to pursue game, knowing that others might steal it at the last moment. He argues for a more nuanced rule: when a person is in hot pursuit of a wild animal with a reasonable prospect of capture, that person acquires an inchoate property right that should be protected from interference by others. Justice Livingston cites many of the same authorities as the majority, but he interprets them differently. He points to legal scholars who suggested that pursuit alone, when earnest and likely to succeed, creates a claim to the animal. He emphasizes the practical importance of protecting hunters from interference. His dissent also appeals to fairness and common sense. Post did all the work. His dogs tracked and chased the fox. He was moments from capture. To allow Pierson to simply step in and take the fox seems unjust, seems to violate basic notions of fair play. Justice Livingston distinguishes between different types of pursuit. He's not saying that merely seeing a wild animal and starting to chase it creates a property right. But when the pursuit is close, continuous, and clearly about to succeed, when the hunter has deprived the animal of its natural liberty through the chase even if not yet through physical capture, then interference should be prohibited. His dissent argues that the majority's rule will discourage the useful activity of hunting vermin. If hunters know that others can steal their prey at the last moment with no legal consequence, they may not bother hunting at all. The dissent is eloquent and compelling. It represents a different vision of property law, one that's more flexible, more concerned with fairness and policy, more willing to protect those who do the work even before they achieve actual possession. But it's a dissent. The majority's opinion becomes the law. Lodowick Post loses his case. The fox belongs to Jesse Pierson, and Post's damages award from the lower court is reversed. We don't know how Post reacted to this decision, whether he and Pierson ever reconciled, whether this dispute festered in their community for years to come. What we do know is that this dispute over a single fox on a Long Island beach, becomes one of the most famous cases in American legal history. Law students to this day, more than 2 centuries later, study Pierson versus Post. It's typically one of the first cases taught in property law courses. Generations of lawyers have read Justice Tompkins's majority opinion and Justice Livingston's dissent, have debated which position is more convincing, have grappled with the fundamental questions the case raises. Why has this case endured? Why do we still care about a fox that died over 200 years ago? Part of the answer is pedagogical. Pierson versus Post is a perfect teaching case. It's short, relatively simple in its facts, but it raises profound questions about property rights. It shows how reasonable judges can disagree. It demonstrates how ancient legal principles get applied to new situations. It reveals the policy considerations that underlie legal rules. But the case's fame also reflects something deeper. The questions it raises are timeless. How do we acquire property? What creates ownership? How do we balance clarity and certainty against fairness and flexibility? When should the law protect effort and investment even before they've resulted in actual possession? These questions arise far beyond fox hunting. They arise in intellectual property. When does an idea become someone's property? They arise in the digital age. Who owns information, content, data? They arise in resource extraction. What gives someone the right to oil or minerals beneath the ground? They arise in space law. How do we allocate property rights in the cosmos? Pierson versus Post doesn't answer all these questions, of course. But it provides a framework for thinking about them. It shows us the tension between different approaches to property, different values that the law might serve. Let's explore more deeply the 2 competing theories that Pierson versus Post embodies. Understanding these theories will help us appreciate why this case remains relevant. The first theory, the one the majority adopts, we might call the bright line rule or the actual possession theory. This theory says that property in wild animals requires actual, physical possession. Until you have captured and contained the animal, it belongs to no one and anyone may take it. The advantages of this theory are clarity and certainty. Everyone knows when an animal has been captured. There's no need for subjective judgment about whether capture was inevitable or whether pursuit was sufficiently close. The rule is easy to apply and prevents disputes. This theory also respects the fundamental nature of wild animals. They are free, belonging to no one, until someone actually controls them. To give property rights based on mere pursuit would be to restrict freedom, both the animal's freedom and other people's freedom to hunt. The second theory, the one Justice Livingston advocates in dissent, we might call the pursuit rule or the inchoate right theory. This theory says that earnest pursuit with a reasonable prospect of capture creates a property right that should be protected from interference. The advantages of this theory are that it rewards effort and protects investment. The hunter who does the work of tracking and pursuing shouldn't have the fruits of that labor stolen at the last moment. This theory also encourages useful activities like hunting vermin. If hunters know their efforts will be protected, they're more likely to hunt. This theory recognizes that possession isn't always instantaneous. There's a process of acquiring possession, and the law should protect that process from interference. Property rights, in this view, can begin to form before actual possession is achieved. These 2 theories represent different philosophies of property law. The first emphasizes clarity, bright line rules, and formal possession. The second emphasizes fairness, protection of labor, and recognition of inchoate rights. Both theories have merit. Both have been influential in different areas of property law. And the tension between them continues to shape legal debates today. Let's consider how the principles from Pierson versus Post apply in other contexts. This will help illustrate why the case remains relevant far beyond fox hunting. Consider whaling in the 19th century. whaling was a major industry, and dispute sometimes arose when one crew harpooned a whale and was pursuing it, only to have another crew kill and capture the whale. Some whaling communities developed customs that gave property rights to the crew that first struck the whale with a harpoon, even if that crew hadn't yet killed or captured it. These customs reflect the pursuit rule that Justice Livingston advocated. Courts that heard whaling disputes generally respected these customs, recognizing that the special circumstances of whaling, the difficulty and danger of the hunt, the mobility of the prey, the established customs of the industry, justified departure from the strict rule of actual possession. Consider oil and gas law. Oil and gas beneath the surface are generally considered analogous to wild animals. They flow freely underground, belonging to no one until captured. The rule of capture in oil and gas law says that whoever extracts oil or gas from the ground owns it, even if it flowed from beneath a neighbor's land. This rule leads to competitive drilling and sometimes wasteful extraction practices, as multiple parties try to capture the resource before others do. It's similar to the problem Justice Livingston worried about in Pierson versus Post. The rule doesn't protect the investment of effort and can lead to socially wasteful behavior. Consider water rights, particularly in the arid American West. Two different systems developed: riparian rights, the eastern system, which gives rights based on ownership of land adjacent to water, and prior appropriation, the western system, which gives rights based on who first diverted and used the water. Prior appropriation is more like the pursuit rule. It protects those who make the effort to capture and use the resource, even if they don't literally possess the water itself. Consider intellectual property. When does an idea become property? Copyright law generally requires fixation in a tangible medium. You can't copyright an idea in your head, you must write it down or record it somehow. This is similar to the actual possession requirement in Pierson versus Post. But patent law allows you to file a provisional application that establishes priority based on conception and effort toward reduction to practice, more like the pursuit rule. Consider finds of treasure or archaeological artifacts. Generally, the rule is finders keepers. Whoever finds and takes possession of abandoned property becomes the owner. But many countries have laws that give the state ownership of archaeological resources, protecting them from private appropriation. These laws reflect a judgment that the strict possession rule isn't appropriate for certain types of property. Consider internet domain names. When the domain name system was created, people could register domain names on a first-come, first-served basis, a pure possession rule. But this led to cyber-squatting, people registering names they had no intention of using, just to sell them to others. Laws were developed to protect trademark owners and penalize cyber-squatters, reflecting a move toward protecting prior effort and legitimate claims rather than rewarding whoever acts first. In all these contexts, we see the same tension that animates Pierson versus Post. Should the law require actual possession to create property rights, or should it protect effort, pursuit, and inchoate claims? The answer varies depending on the context, the type of property, the relevant customs and expectations, and the policy goals we want to achieve. Let's go even deeper into the philosophical questions that Pierson versus Post raises. Why do we have property rights at all? What purpose do they serve? One theory, associated with the philosopher John Locke, is that property rights arise from labor. When you mix your labor with something from nature, it becomes yours. You plant and tend a garden, the vegetables are yours. You cut down a tree and build a house, the house is yours. Property is the fruit of your labor. This labor theory suggests that Justice Livingston's dissent in Pierson versus Post is correct. Lodowick post-labored to pursue the fox. He mixed his effort with the natural resource of the wild animal. Therefore, he should have a property claim. But the majority opinion reflects a different view. Property requires not just labor but also actual control, actual possession. Until you have physical dominion over something, it's not yours. This view emphasizes the importance of clear boundaries and definite rules. Another theory of property, associated with utilitarian philosophers like Jeremy Bentham, is that property rights exist to maximize social welfare. We protect property because doing so encourages productive activity, enables commerce, and creates stability. The question then becomes, which rule, possession or pursuit, creates better incentives and better outcomes? The majority in Pierson versus Post might argue that their rule is better for social welfare because it's clear and prevents disputes. But Justice Livingston might counter that his rule is better because it encourages the useful activity of hunting vermin and protects those who invest effort. Yet another theory sees property as arising from first occupancy or prior claim. Whoever gets there first, whoever takes possession first, has the superior claim. This is a simple rule that avoids conflict over scarce resources. It's the rule reflected in the majority opinion. Whoever first kills and possesses the fox owns it. But we might also think about property in terms of fairness and desert. People should own what they deserve based on their effort, their need, or their prior claims. This view is more sympathetic to Lodowick Post. He did the work, he deserves the reward. Different property systems throughout history have reflected different philosophical foundations. Roman law, medieval feudalism, modern capitalism, socialist systems, each has its own theory of what creates property and who should own what. Pierson versus Post forces us to confront these fundamental questions. It's not just about a fox, it's about what we believe property is and why we believe in it. To fully appreciate Pierson versus Post, we should understand the social context in which it arose. What was early 19th century America like? How did people think about property and law? The United States in 1805 is still a young nation. The Constitution was ratified less than 20 years earlier. The country is in the process of defining itself, including its legal system. American courts are working out how English common law will be adapted to American circumstances. This is an era of territorial expansion. The Louisiana Purchase has just occurred in 1803, doubling the size of the country. Americans are moving westward, settling new lands, exploiting new resources. Questions about property, who owns what, how ownership is acquired, are urgent and practical. It's also an era of relatively limited government. There are fewer regulations, fewer statutes governing property and commerce. Common law, judge-made law based on precedent and principle, plays a much larger role than it does today. Cases like Pierson versus Post are important because they establish principles that will guide future decisions. Fox hunting in this era is a gentleman's sport, but it's also practical pest control. Foxes really do threaten farm animals. Hunting them is considered a public service. The question of who gets the reward for killing a fox is not trivial to these communities. Social status and honor matter greatly in early 19th century America. A dispute like the one between Post and Pierson is not just about money or about a fox, it's about respect, reputation, and standing in the community. Being wronged publicly, as Post must have felt he was, demands vindication. Going to court is a way of asserting your dignity and your rights. The legal profession itself is still developing. Lawyers in this era are often self-taught or trained through apprenticeship. Legal education is not yet standardized. Yet there's great respect for learning, for classical education, for knowledge of ancient legal authorities. The lawyers and judges in Pierson versus Post display impressive erudition, citing Roman law and European legal scholars with ease. Understanding this context helps us see why Pierson versus Post matters. It's a case that arises at a formative moment in American legal history, addressing fundamental questions about property in a society that's expanding, developing, and defining its legal principles. Let's return to Justice Livingston's dissent and consider more carefully the alternative legal world it envisions. What would property law look like if his view had prevailed? If courts had adopted the pursuit rule, property law would likely be more flexible, more fact-specific, more concerned with fairness and policy than with bright-line rules. Judges would have to make case-by-case determinations about whether a pursuit was sufficiently earnest, whether capture was sufficiently likely, whether interference was wrongful. This might lead to less certainty in a short run. Parties might not know for sure who owns what until a court decides, but it might lead to fairer outcomes and better incentives. Hunters would know their efforts would be protected. People would be discouraged from interfering with others' legitimate pursuits. We can see echoes of Justice Livingston's approach in various areas of modern law. Adverse possession, for example, allows someone to acquire property rights in land through long-term use even without formal title. It's a recognition that possession and use can create property rights over time. Trademark law protects marks based on use, not just formal registration. Salvage law rewards those who rescue property in distress, even though they don't own it. In all these areas, the law recognizes that actual possession isn't the only way to acquire property rights. Effort, investment, reasonable expectations, and legitimate claims can also matter. Justice Livingston's dissent represents a vision of property law that's more attuned to human behavior and social norms, even if it sacrifices some clarity. It's a vision that asks, what rule will lead to the best outcomes? What rule will encourage productive activity? What rule accords with our sense of fairness? The majority opinion, by contrast, represents a vision that prioritizes clarity and administrability. It asks, what rule can be applied consistently? What rule minimizes disputes? What rule respects the fundamental nature of wild things? Both visions have merit, and the tension between them continues to shape property law to this day. Let's delve deeper into the Roman law authorities that both the majority and dissent cite so heavily. Understanding these ancient sources helps us appreciate how legal reasoning works, how judges draw on tradition while adapting it to new circumstances. Roman law, particularly as codified in Justinian's Institutes in the 6th century AD, addressed the question of property in wild animals extensively. The Romans recognized several ways of acquiring ownership, and occupancy, taking possession of things that belong to no one, was one of them. The Institutes state clearly, wild animals, birds, and fish, that is to say all the creatures which the land, the sea, and the sky produce, as soon as they are caught by anyone become at once the property of their captor by the law of nations, for natural reason admits the title of the first occupant to that which previously had no owner. This seems to support the majority's position in Pierson versus Post. Property arises when the animal is caught, captured, possessed. But the Institutes go on to address a complication. It is deemed immaterial whether it is on his own land or on that of another that a person catches wild animals or birds. At the same time, anyone who goes upon another's land for the sake of hunting or fowling can be prohibited by the proprietor from entering if he perceives his intention. This passage introduces the notion that landowners have some rights to exclude hunters, even though the wild animals themselves belong to no one. It's a recognition that property rights in land and property rights in wild animals interact in complex ways. The Institutes also address what happens to wounded animals. Wild animals are understood to continue yours so long as they are in your custody, but when they have escaped from your custody and recovered their natural liberty, they cease to be yours and once more become the property of the first person who captures them. They are deemed to have recovered their natural liberty when they have escaped out of your sight, or when, though still in your sight, their recapture has become difficult. This passage is particularly interesting. It suggests that possession of a wild animal is maintained only so long as custody continues. Once the animal escapes and recapture becomes difficult, it returns to its wild state. This seems to support the majority's view that until actual capture occurs, the animal belongs to no one. But notice the nuance: the animal must have escaped from your custody. This implies that it was at some point in your custody. What about an animal you're chasing but haven't yet captured? The institutes don't directly address this scenario. Roman jurists also discuss the case of wounded animals. If you wound a wild boar and it runs away, do you have a claim to it if someone else finds and kills it? Different authorities gave different answers. Some said the animal remained wild and could be taken by anyone. Others suggested that if the wound was mortal and recapture was likely, the hunter retained some claim. These Roman sources show that even in ancient times, lawyers and judges grappled with the same questions that Pierson versus Post raises. The answers were not always clear or unanimous. Different principles, clarity versus fairness, formal possession versus reasonable expectation, could point in different directions. The judges in Pierson versus Post also drew on English legal traditions, so let's explore those briefly. Medieval England had elaborate laws governing hunting, though they were concerned primarily with protecting the rights of nobility and landowners rather than with the abstract question of when wild animals become property. In medieval England, hunting was a privilege largely restricted to the aristocracy. The forest laws, established by William the Conqueror and his successors, reserved vast tracts of land for royal hunting. Commoners who hunted in royal forests could face severe penalties, mutilation, even death in the harshest periods. These laws were about preserving game for the pleasure of the king and nobility, not about determining property rights in a neutral, philosophical sense. They reflected a hierarchical society where rights depended on social status. Over time, English law developed the concept of property in game. Landowners had exclusive hunting rights on their land. Poaching, hunting on another's land without permission, was a crime. But this was understood as a violation of the landowner's property rights in the land, not necessarily as theft of the wild animals themselves. The distinction is subtle but important. The landowner could exclude others from hunting on his land, but the wild animals themselves didn't belong to the landowner until captured. They were Ferae Naturae, wild by nature. The landowner's right was a right to be the only one allowed to pursue and capture them on his property. English common law also developed the concept of ration soli, property in wild animals by reason of the soil. This meant that landowners had a qualified property right in the wild animals on their land. It was qualified because it wasn't full ownership, the animals remained wild, but it gave the landowner the exclusive right to hunt them. When English colonists came to America, they brought these legal concepts with them. But America was different. There was no monarchy, no aristocracy with exclusive hunting rights. In principle, at least, all citizens had equal rights to hunt game, subject to whatever regulations the states might impose. This democratic transformation of hunting rights made cases like Pierson versus Post more likely to arise. When everyone has the right to hunt, disputes about who captured what become more common. The courts needed clear rules to resolve these disputes. The case arose on a beach that apparently wasn't privately owned, or at least where Post didn't have exclusive hunting rights. In this context, both Post and Pierson had equal rights to hunt. The question was purely about who acquired property in the fox first, through pursuit or through capture. One interesting aspect of Pierson versus Post is what it doesn't tell us. What were the customs and expectations of the hunting community on Long Island in 1802? Did hunters have informal rules about respecting each other's pursuits? Would Pierson's conduct have been considered acceptable or auditionable by his peers? In many communities, especially close-knit ones, informal norms and customs regulate behavior in ways that formal law does not. Hunters might have unwritten rules. Don't interfere with another hunter's chase. If someone's dogs are pursuing game, let them finish the hunt. These norms, backed by social pressure and community opinion, can be more effective than legal rules. We see this in the whaling example mentioned earlier. Whaling communities developed elaborate customs about who owned a whale when multiple crews were involved in its capture. These customs were respected by courts, which recognized that the participants in an industry often develop rules better suited to their specific circumstances than general legal principles would be. If there were hunting customs on Long Island that gave priority to the pursuer, then Pierson's conduct might have been seen as dishonorable even if technically legal. The lawsuit itself might have been as much about vindicating Post's reputation and enforcing community norms as about the monetary value of the fox. Unfortunately, the court opinions don't discuss local customs. Justice Tompkins's majority opinion focuses on general legal principles drawn from Roman law and European authorities. Justice Livingston's dissent similarly reasons from first principles rather than from local practice. This omission might reflect the formality of legal reasoning in this era, a preference for universal principles over particular customs. Or it might simply reflect the lack of clear, established customs that the court could point to. In modern property law, custom and industry practice often play important roles. Courts recognize that people who work in particular fields develop expertise and norms that deserve respect. The law of salvage at sea, for example, incorporates the customs of mariners. The law governing oil and gas often respects industry practices. But in Pierson v. Post, the court was establishing a general rule about property in wild animals, a rule that would apply not just to fox hunting but to many other contexts. For such a general rule, universal principles might be more appropriate than particular customs. Let's think about Pierson v. Post from an economic perspective. What are the economic implications of the different rules the case considers? Economists who study property law often focus on incentives. Property rights create incentives to invest in acquiring, improving, and maintaining resources. The question is, which property rule creates the best incentives? The majority's rule, actual possession required, has certain economic advantages. It's clear and easy to enforce, which reduces transaction costs and prevents disputes. Everyone knows when property rights have been established. But the majority's rule might create perverse incentives in some contexts. If anyone can take the fruits of your labor at the last moment, you might invest less effort in pursuit. This is especially true when pursuit is costly or risky. Why spend hours tracking a fox if someone can steal it just before you catch it? This is what economists call a commons problem or a tragedy of the commons. When resources are unowned and anyone can take them, people might overexploit the resource, everyone racing to grab it first, or underinvest in pursuing it. Why bother if others will steal it? Justice Livingston's pursuit rule might create better incentives in this regard. If the law protects your pursuit, you're more likely to invest effort in hunting. This could lead to more efficient resource use, more foxes hunted, less wasteful competition. But the pursuit rule has its own economic drawbacks. It's less clear, which means more disputes and higher enforcement costs. Courts would have to make difficult judgments about whether a pursuit was sufficiently earnest and likely to succeed. Litigation would increase. The pursuit rule might also create a different perverse incentive. People might engage in symbolic or minimal pursuit just to establish a claim, without any real intention or ability to capture the animal. The rule could reward effort even when that effort is wasteful or ineffective. Economists would also consider the value of the resource at stake. For low-value resources like a single fox, perhaps a simple, clear rule is best, even if it sometimes produces unfair results. The costs of administering a more complex rule might exceed the benefits. For high-value resources, by contrast, it might be worth having a more nuanced rule that better aligns incentives and protects investment. This is why we see more complex property rules for things like oil and gas, mineral rights, and intellectual property than we do for wild animals. The economic analysis doesn't give us a definitive answer about which rule is better. It depends on the context, the value of the resource, the costs of different types of errors, and the importance of various economic and social goals. Let's bring Pierson versus Post into the modern era by considering how its principles apply to digital resources and the Internet. This will show how a case about a fox from 1805 remains surprisingly relevant today. Consider domain names, which we touched on earlier. In the early days of the Internet, domain names were essentially unowned resources, available to anyone who registered them first. This led to cyber-squatting. People registered domain names not to use them but to sell them to others who wanted them, particularly trademark owners. Is this like Pierson killing Post's fox? The cyber-squatter hasn't invested any labor in creating value. They've simply taken possession of something that was available. Under the majority rule in Pierson versus Post, whoever takes possession first has the superior claim. But Congress and courts eventually decided this wasn't the right rule for domain names. The Anti-Cyber-Squatting Consumer Protection Act and the Uniform Domain Name Dispute Resolution Policy allowed trademark owners to reclaim domain names from cyber-squatters. This is more like Justice Livingston's approach, protecting those with legitimate prior claims and investment. Consider data and information on the Internet. Who owns information? If you collect data about people's behavior, does it belong to you? If someone scrapes your website and takes that data, have they stolen your property or simply taken possession of something that was publicly available? These questions echo Pierson versus Post. Is data like a wild animal, unowned until someone captures it? Or does the person who invested effort in collecting and organizing data have a prior claim that should be protected? Consider open source software and Creative Commons. These are intentional rejections of traditional property models. Creators release their work into a commons where anyone can use and build upon it. This is like deciding that wild animals should remain wild and free, available to all. But even in open source communities, there are norms and expectations. If you take someone's open source code and claim it as your own without attribution, you've violated community norms even if you haven't broken any law. This is similar to how Pierson might have violated hunting norms even if he technically had a legal right to take the fox. Consider artificial intelligence and machine learning. AI systems are trained on vast amounts of data gathered from the Internet. Who owns the outputs of these systems? The AI company that built and trained the model? The people whose data was used for training? The person who writes the prompt? These questions force us to think about property in new ways, just as Pierson versus Post forced courts to think carefully about when wild animals become property. The principles at stake, labor, possession, prior claim, social benefit, are the same, even if the context is radically different. Let's consider how modern environmental consciousness might inform our reading of Pierson versus Post. In 1805, no one was thinking about wildlife conservation or ecosystem management. Foxes were pests to be eliminated. More hunting was considered beneficial. Today, we have very different attitudes toward wild animals. We recognize that wildlife populations can be depleted or destroyed. We understand that animals play important roles in ecosystems. We value biodiversity. Many people believe animals have intrinsic worth beyond their utility to humans. Modern wildlife law reflects these values. Hunting is heavily regulated. Many species are protected. The state often claims ownership of wildlife on behalf of the public, managing it as a common resource. The goal is sustainable use, not unlimited exploitation. If Pierson versus Post arose today, the court might consider environmental factors. Does the rule we adopt encourage overhunting or sustainable hunting? Does it lead to wasteful competition or efficient resource management? What impact will it have on wildlife populations? The majority's rule, possession required, might actually promote conservation in some contexts. If no one owns an animal until it's captured, then no one has an incentive to kill more animals than they can actually use. There's no point in killing an animal you can't possess. But the pursuit rule might also have conservation benefits. If the law protects hunters who invest time and effort, it might reduce wasteful competition and encourage more selective hunting. Hunters would compete less on speed and more on skill. In practice, modern wildlife law doesn't rely on either rule from Pierson versus Post. Instead, it relies on comprehensive regulation, hunting seasons, bag limits, licensing requirements, protected species, and so on. The state manages wildlife populations directly rather than leaving allocation to be determined by common law rules about possession and pursuit. But the underlying questions remain relevant. How do we balance competing claims to natural resources? How do we allocate access to common resources? How do we encourage sustainable use? These questions, which Pierson versus Post addresses in its 19th century context, continue to challenge us in new forms. Let's shift to a different perspective, the psychology of property. How do people actually think and feel about ownership? Does our psychological experience of property align with the legal rules? Psychologists have found that people have strong intuitions about property that often precede and shape legal rules. Children as young as 2 years old understand possession and ownership. We seem to have innate tendencies to claim things, to defend our possessions, to feel that what we have is ours. Research also shows that people have strong intuitions about labor and property. When someone mixes their labor with a resource, people tend to feel that person has earned ownership. This is exactly the Lockean theory of property we discussed earlier, and it turns out to be deeply intuitive for most people. From this psychological perspective, Lodowick Post's claim seems compelling. He did the work. He chased the fox. Most people's intuitive sense of fairness says the fox should be his. Jesse Pierson just swooped in at the last moment. That seems wrong, unfair, a violation of basic principles of desert and reward. But psychologists have also identified what they call the endowment effect. Once we possess something, we value it more highly than we did before we possessed it. Possession itself creates psychological ownership. Jesse Pierson, having killed and taken the fox, probably felt it was genuinely his. Possession is powerful psychologically, not just legally. People also have strong intuitions about physical control and possession. We feel that something is ours when we hold it, when we can touch it, when we have physical dominion over it. This too supports the majority's rule in Pierson versus Post. Actual possession creates a psychological sense of ownership that mere pursuit does not. Interestingly, research shows that different cultures have somewhat different intuitions about property. Individualistic cultures tend to emphasize possession and control. More communitarian cultures might emphasize need, use, and social relationships. These cultural differences can lead to different property systems. The American legal system, shaped by individualistic values, tends to emphasize possession and control, which might explain why the majority's rule in Pierson versus Post prevailed. In a different cultural context, the outcome might have been different. Understanding the psychology of property helps us see why Pierson versus Post is such a difficult case. Both sides have claims that resonate with our psychological intuitions. Post appeals to our sense that labor deserves reward. Pierson appeals to our sense that possession creates ownership. No wonder the judges divided. Let's talk about why Pierson versus Post is such a beloved teaching case in law schools. This will help us understand the case's broader significance. Law professors love Pierson versus Post because it's the perfect first case for a property course. It's short and readable, a few pages, not the dozens or hundreds of pages that some cases generate. The facts are simple and vivid. Everyone can picture a fox chase on a beach. The legal reasoning is clear and accessible. But more importantly, the case raises fundamental questions that will occupy students throughout the entire course. What is property? How is it acquired? What purposes do property rules serve? How do we balance competing values like certainty and fairness? The case also introduces students to legal reasoning and legal culture. They see how judges cite ancient authorities, how they reason by analogy, how they consider policy implications. They learn that the law is not just a set of rules but a mode of thinking, a way of analyzing problems. The divided opinion is pedagogically valuable. Students can't just accept what the court says, they have to evaluate the competing arguments. Many students find themselves sympathizing with Justice Livingston's dissent. This teaches them that law is not always settled, that reasonable people can disagree, that being a lawyer means making arguments and choices, not just looking up answers. Professors use Pierson versus Post to introduce various analytical frameworks. They might ask students to analyze the case using economic reasoning, or feminist theory, or critical race theory, or law and economics. The case is simple enough to be a good vehicle for these different methodologies, but rich enough to yield interesting insights. The case also provokes discussion about the role of judges. Should judges follow clear rules even when they lead to seemingly unfair results, as the majority did? Or should judges craft more flexible rules that achieve justice in particular cases, as the dissent advocated? These questions about judicial role and legal interpretation recur throughout law school and legal practice. Many law students remember Pierson versus Post years later, long after they've forgotten other cases. There's something memorable about the Fox chase, about the clear conflict between Post and Pierson, about Justice Livingston's passionate dissent. The case sticks with you. And perhaps most importantly, the case is fun. Legal education can be grueling, but Pierson versus Post reminds students why law can be intellectually exciting. It's a puzzle, a story, a debate about fundamental questions of justice and social order. Let's return to where we started, the human story of Lodowick Post and Jesse Pierson. We've spent considerable time on legal principles and philosophical questions, but at the heart of this case are two real people who had a real conflict. What happened to them after the case was decided? We don't have complete records, but we can piece together some information and make some reasonable inferences. Lodowick Post lost his lawsuit. The fox he chased belonged to Jesse Pierson. Post had to pay court costs. This must have been frustrating, even infuriating. He'd done everything right, pursued the fox earnestly with trained dogs, been moments from capture, and the law said he had no claim. Did Post accept the court's decision gracefully, or did he remain bitter? We don't know. But in small communities like Southampton, people have to live with their neighbors. Post and Pierson likely saw each other regularly after the lawsuit ended. They might have passed each other on the street, encountered each other at community gatherings, done business with each other's family members. Jesse Pierson won the case, but did he really win? His reputation might have suffered. Even if the law was on his side, community opinion might have been against him. People might have viewed his conduct as unsportsmanlike, as violating the unwritten rules of fair play. The fox he kept was worth very little money, but the lawsuit and the community judgment might have cost him considerably more. Or perhaps Pierson was seen as standing on principle, refusing to be bullied by Post's claims. Perhaps he was admired for his independence, for not kowtowing to the Post family's presumed superiority. The community's reaction likely depended on various social factors we can only guess at. Both men were property owners, presumably men of some means if they had time for fox hunting and money for lawsuits. They were part of the local establishment. This wasn't a case of rich versus poor or powerful versus powerless. It was a dispute between peers, which perhaps made it harder to resolve informally. The case might have damaged their relationship permanently, or it might have eventually blown over. Old disputes sometimes fade, sometimes they harden into lasting enmity. In families and communities, conflicts can be passed down through generations, or they can be forgotten as new concerns arise. What we do know is that Lodowick Post and Jesse Pierson, whatever their intentions, created something that outlasted them both. Their dispute over a fox became a landmark case, studied by millions of law students, cited by countless courts, part of the permanent fabric of American law. Neither man could have imagined this outcome when they argued on that beach in 1802. They thought they were fighting over a fox. They were actually creating legal history. As we near the end of our journey through Pierson versus Post, let's reflect on the case through analogy and metaphor. Sometimes these can illuminate aspects of the case that pure legal analysis might miss. The fox chase is like many pursuits in life. You work hard toward a goal, a job, a relationship, an achievement, and just when success seems certain, someone else steps in and claims what you thought would be yours. Is that fair? Does your effort entitle you to the reward, or does the person who actually achieves the final step deserve it? In competitive contexts, we often struggle with this question. Consider job applicants. If you've gone through multiple interview rounds and seem likely to get an offer, but someone else is hired, do you have any claim? Of course not legally, but there's still a sense of disappointment, even in justice. You invested time and effort, raised your hopes, and then lost out. Or consider romantic pursuit. If you've been courting someone and another person succeeds in winning their affection, you might feel what Lodowick Post felt, that your investment, your effort, your near success should count for something. But of course, people aren't property, and no amount of pursuit creates a claim on another person. The analogy breaks down, but the emotional experience is similar. The case is also a metaphor for different approaches to life and law. The majority opinion represents a conservative, formalistic approach, follow the clear rule, avoid complexity and subjectivity, value certainty over flexibility. Justice Livingston's dissent represents a progressive, equitable approach, consider the circumstances, pursue fairness, protect those who invest effort. These different approaches appear throughout law and throughout life. Do we prefer bright-line rules that are easy to apply but sometimes produce harsh results? Or do we prefer flexible standards that require judgment but can achieve justice in particular cases? There's no simple answer, the choice depends on context and. The fox itself is a powerful symbol. Wild, free, belonging to no one, until captured. The fox represents nature, untamed and unowned. The dispute over the fox is really a dispute about how humans relate to nature, how we impose our systems of ownership and control on a world that exists independently of those systems. In our modern world, where we're increasingly aware of environmental limits and the importance of wildlife, the image of men chasing a fox to kill it might seem troubling. But we can also see it as a metaphor for resource allocation generally. How do we decide who gets scarce resources? The principles we develop for foxes might apply to water, minerals, fish, bandwidth, or any other limited resource. Pierson versus Post has occasionally appeared in popular culture, usually as a reference that law students and lawyers recognize. It's become a kind of inside joke or shared cultural touchstone for the legal profession. Law school parodies and comedies sometimes reference the fox case as emblematic of the arcane, seemingly pointless questions that law students must grapple with. Who cares about a fox from 200 years ago? Why does this matter? These are questions every first-year law student asks. But the joke is ultimately on the skeptics, because the case does matter. It matters because property law matters, because the principles of acquisition and possession matter, because understanding how courts reason matters. The Fox case teaches all of these things. There have been mock trials and reenactments of Pierson versus Post, with law students or lawyers playing the roles of Post, Pierson, and the judges. These performances highlight the drama of the case, the chase, the conflict, the passionate arguments on both sides. Some creative works have used Pierson versus Post as inspiration. Stories about property disputes, about the nature of ownership, about wild animals and human claims to them, these sometimes nod to the Fox case, recognizing its place in legal law. The case has also inspired law professors to create hypothetical variations, testing students' understanding by changing the facts. What if Post had wounded the fox? What if the chase occurred on Post's land? What if the fox was a rare, valuable species? What if Post and Pierson had an agreement about hunting? These variations help students see how the legal principles work in different contexts. In the age of the internet, Pierson versus Post has found new life. Law blogs discuss it. Legal podcasts dissect it. Memes reference it. The case has become more accessible and more widely known than ever before, reaching beyond law schools to anyone curious about law and justice. This cultural presence, modest though it is, reflects the case's enduring significance. A good story, a clear conflict, fundamental questions, these are the ingredients of lasting relevance. As we approach the end of our time with Pierson versus Post, let's reflect on the question of justice. Was the case decided justly? If we favor the majority's rule, we might say justice was served. The law requires actual possession to create property in wild animals. Post didn't have possession, Pierson did. Therefore, Pierson wins. Justice means following the law consistently, even when the result seems harsh. This is a formalist conception of justice, justice as adherence to rules. The rules exist for good reasons. They create predictability, prevent disputes, treat like cases alike. To depart from the rules in pursuit of a fairer outcome in a particular case would undermine the rule of law itself. But if we favor Justice Livingston's dissent, we might say justice was not served. Post did the work, was moments from success, and deserved the fox. Pierson's conduct was wrongful interference, not legitimate acquisition. Justice means protecting those who invest effort and preventing unjust enrichment. This is an equitable conception of justice, justice as fairness in particular cases. Rules are important, but they must serve justice, not obstruct it. When a rule produces an unjust result, courts should recognize exceptions or craft new rules that better serve equity. These two conceptions of justice, formal and equitable, have coexisted in legal systems for centuries. Sometimes they conflict, as they do in Pierson versus Post. The challenge is finding the right balance. Perhaps justice in this case is not about who got the fox, but about how the dispute was resolved. Post and Pierson took their conflict to court rather than resolving it through violence or ongoing feud. They accepted the court's authority to decide. They abided by the decision, even though Post surely disagreed with it. This is procedural justice, justice as fair process. Even if we think the outcome was wrong, we can recognize that the process was fair. Both sides presented arguments. Learned judges considered the matter carefully. The losing party had the opportunity to appeal. The decision was explained and reasoned, not arbitrary. In this view, Pierson versus Post represents the triumph of law over private force, of reason over passion, of social order over chaos. That's a kind of justice, even if the particular result seems unfair. We might also think about corrective justice versus distributive justice. Corrective justice is about rectifying wrongs, restoring parties to their rightful positions. Distributive justice is about fair allocation of benefits and burdens across society. The majority opinion in Pierson versus Post might seem to fail at corrective justice. It doesn't correct what seems like Pierson's wrong to Post. but it might serve distributive justice by establishing a clear, administrable rule that will fairly govern countless future disputes. Justice, we might conclude, is not simple. Different kinds of justice can conflict. Reasonable people can disagree about what justice requires. Pierson versus Post illustrates this complexity beautifully. Pierson versus Post endures because it raises questions that every generation must answer for itself. As we close our exploration of this case, let's consider what questions it leaves us with. What creates ownership? This is the fundamental question. Is it labor, as Locke suggested? Is it possession, as the majority held? Is it social recognition, as some theorists argue? Is it first claim, or best use, or legal decree? We've explored these questions, but we haven't definitively answered them, because perhaps they can't be definitively answered. The answer depends on context, values, and social goals. How should law balance certainty and flexibility? Bright-line rules create predictability but can produce harsh results. Flexible standards allow for fairness but create uncertainty. Every legal system must navigate this trade-off, and Pierson versus Post presents it clearly. What is the relationship between law and morality? The majority's rule might be legally correct but morally troubling. Does law have to track our moral intuitions? Should courts pursue justice even when it conflicts with established rules? Or must law maintain its integrity by following rules consistently? How do we value nature and wild things? Are wild animals mere resources to be exploited, or do they have independent value? How should property law reflect our relationship with the natural world? Pierson versus Post was decided in an era of abundance, when wildlife seemed limitless. Our answers today might be different. What role should custom and community norms play in law? Should courts defer to the practices of particular industries or communities? Or should they articulate universal principles that apply regardless of local variation? The case doesn't address hunting customs, but perhaps it should have. How do we allocate scarce resources fairly? This is ultimately what Pierson versus Post is about. When many people want the same limited resource, how do we decide who gets it? First come, first served? Most effort? Greatest need? Best use? Different allocation mechanisms suit different resources and contexts. These questions remain alive today. We face new versions of them constantly, in environmental law, in intellectual property, in the digital realm, in global resource disputes. Pierson versus Post doesn't answer these questions for us, but it gives us a framework for thinking about them, a set of principles and counter-principles to work with. And so we come to the end of our journey through Pierson versus Post. We've spent these hours together, exploring a case about a fox, but really about so much more. About property and possession, labor and reward, rules and fairness, certainty and flexibility. The fox at the center of this case died over 200 years ago, killed by Jesse Pierson on a Long Island beach one autumn morning. But in another sense, the fox still runs free, leading us on a chase through legal history, through philosophical questions, through the eternal human struggle to create order and justice in a complex world. Lodowick Post and Jesse Pierson are long gone. Their dispute, which seemed so important to them, has faded into history. But the principles they forced courts to articulate live on, shaping property law, influencing judges, teaching students, provoking thought. Perhaps there's a lesson in that. The things we fight over may seem monumentally important at the time, but they're often ephemeral. What lasts are the principles, the ideas, the questions we ask and the answers we attempt. Post and Pierson fought over a fox, but they gave us something more enduring, a case that continues to illuminate fundamental questions of law and justice. As you drift off to sleep, you might picture that beach in Southampton, the dogs baying, the fox running, two men on horseback moving across the sand. You might imagine the courtroom where learned judges debated ancient authorities and fundamental principles. You might think about all the law students who have grappled with this case, all the courts that have cited it, all the disputes it has helped resolve. Or you might simply rest, letting these stories and ideas wash over you like waves on that Long Island shore, carrying you gently towards sleep, knowing that when you wake, the questions will still be there, waiting to be pondered again in the light of a new day. The chase continues. The questions remain open. The law evolves. And somewhere in our imagination, on a windswept beach, a fox still runs free, leading us on, teaching us, reminding us that the pursuit of justice, like the pursuit of that fox, is never quite complete, always almost within reach, always worth the effort. Rest well. The story is told.